Hello, everyone, and thank you for joining us today. My name is Pete Land. I'm a partner in Husch Blackwell's education group, and we thank you for joining our program today. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, and we hope that you do, you can submit those via the question box. We will try to answer questions during the webcast today and do the best that we can to get back to you. But if a fuller answer is needed or we run out of time, it will be answered later via email. So we will answer your questions, whether it's live today or in emails in response. Following up. A PDF of the presentation is available in the program materials folder if you want to access that. Towards the end of the program, please be sure to complete our short survey. We really do use your feedback to plan future programs that are applicable to your needs and to your missions of your various institutions. So we really welcome comments and thoughtfulness in those responses to the survey. So that's it for our housekeeping items, and let's get started with our program. Presenting with me today is Mary DeWeese. Mary is a senior associate in our education group and is an education-focused attorney passionate about helping organizations to serve students, faculty, and employees and advance institutional missions. With a master's in education, Mary taught elementary school for 2 years in Washington, D.C. She left the classroom to go to law school and chose to pursue a legal career working with colleges and universities that we serve. And I'm so glad she did, because Mary and I represent together often education institutions in state and federal litigation, administrative proceedings. We conduct investigations and provide counsel on administrative policies, student matters, and employment issues. And that includes addressing issues about free speech, which is the topic of our discussion today, while we address navigating the marketplace of ideas. So this agenda slide gives you a broad sense of what we'll cover today, the topics that we'll cover, the First Amendment generally, academic freedom, some discussion about non-discrimination laws, and then some practical scenarios with some hypotheticals at the end to help sort of exemplify what we've been talking about. One thing I would note is, and to keep in mind, is that our goal today is to really try to help issue spot and to discuss considerations that it's helpful to keep in mind when free speech related issues come up on your campus. I say that because the answer to how to address free speech issues when they arise is rarely a one-size-fits-all model. I've worked for this for decades now, and anytime a free speech issue comes up, either in litigation or in a counseling matter, we really have to revisit all of these topics we're talking about to keep in mind to address the specific situation. They can be relatively complex and intertwined, and it's not always intuitive. So we want to keep that in mind, that today's really about how to figure out what issues to consider, what information to try to gather when you're trying to address thorny issues that relate to free speech on campus. Some other key considerations that may affect any efforts to try to address free speech issues when they come up are listed here. These are more practical considerations to keep in mind. So maybe the first one is that the media cycle, if the issue about free speech is coming up in any way that's covered by media, the media cycle is extremely fast. And it can feel instantaneous if you're helping or trying to help people address those issues, meaning it's a very public issue and people feel like maybe they should respond quickly, like how quickly do we need to make an institutional decision? When and how would the institution respond? And can we do that publicly? These are issues to try to prepare in advance. Again, you don't always have quick answers for this, but you need to keep in mind that they'll put some additional pressure on people to try to figure out how to respond and how to protect the institution's reputation. So it's important to keep in mind that the issues we're talking about are often needed to be addressed in short order. Related to that is the current social media climate that heightens these risks. It used to be it was only media sources with their credentials that could report news. Now it's anybody with a phone who can post on your campus, and they do. So that makes our reputational interests kind of escalate in their importance and the considerations about responding quickly. Along with those kinds of considerations, there are the community instincts versus legal standards that apply to speech protections. These do not always line up entirely, which is why we're going to talk a lot today about the legal standards to keep in mind when addressing these kinds of issues, so you can measure them against the community instincts that your stakeholders may have. The last thing we talk about, which is really important with any speech issue, is that details really matter. So the exact speech at issue is incredibly important. What was said, who said it, where they said it, who heard it, who it was directed to. It's not always just one comment is a problem or one comment is not a problem. It really matters, and it's important. Sometimes it's hard to get the details about exactly what was said right away, and it's really important to do that before making decisions. And it's also important to review your policies that relate to issues such as access to forums on campus or academic freedom or any speech-related policy, both at public institutions, but particularly private institutions, because the source of authority over or a challenge over what you do on a private institution will come from policies, not from the First Amendment itself, which only applies to public institutions. And with that, I'll turn it over to Mary.
Thanks, Pete. So we're going to start by diving into a refresher on the key principles of the First Amendment. This isn't meant to be the equivalent of a constitutional law class, but rather a chance to review the basic freedom of speech principles and how they apply on college campuses. So to start, as you all know, the right to free speech comes from the First Amendment to the Constitution, which provides that Congress cannot make laws establishing a religion, restricting the free exercise of a religion, restricting the freedom of speech or the press, etc. And the First Amendment is, as Pete said, applicable to our public colleges and universities. That does not mean that these next few slides aren't relevant to those of you at private institutions, which may have, as Pete said, policies or handbooks that incorporate some free speech principles and give rise to speech protections on campus still. So the vast majority of speech is subject to protection. This includes speech that's unpopular and speech that's religious in nature. And there are, of course, categories of unprotected speech, specifically speech which incites violence, speech which is considered to be a true threat, fighting words, obscenity, and defamation. These standards are really specific, and we're going to talk about them in a moment. The standards for unprotected speech, that is. We're going to start by just going over sort of the basic ideas of protected speech. So first, if there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. The First Amendment does not recognize exceptions for bigotry, racism, or religious intolerance, or ideas or matters which some may deem trivial, vulgar, or profane. So, as we'll talk about later, this principle can sometimes butt up against university policies against harassment and discrimination, which creates complex situations for those of you on campus. Now, in the quote, or in the case that this quote comes from, which comes from an Eastern District of Michigan decision that was ultimately affirmed by the Sixth Circuit, the court held that a university's anti-harassment policy was unconstitutional, but also held that the university's action in disciplining a coach for his speech in violation of that policy was not unconstitutional. In other words, finding for both parties. And that determination was on the basis of some employee speech principles that we'll talk about in a moment. But it really, in addition to being a good quote for the idea that unpopular speech is protected, the case really highlights how complicated and fact-based litigation on the basis of free speech on a college campus is. And in recent years, the Supreme Court has indicated that the protection of religious speech is a priority. The most recent campus speech decision to be issued by the Supreme Court is the Kennedy decision, which came out about 2 years ago. In that case, a high school football coach had a practice of praying at the 50-yard line after games. And the school district, worried about Establishment Clause implications, asked that he pray elsewhere. He declined to do so and eventually had his contract non-renewed. The Supreme Court sided with the coach on both his free speech and free exercise claims. And the court explained that the Constitution doubly protects religious speech through the freedom of speech clause and the free exercise clause of the First Amendment. Now, in that case, the court ultimately found that the coach's speech wasn't pursuant to his duties, that he was engaging in private speech. And it's an important case in that it showcases the length that the court will go to protect speech that's religious in nature. And now I'm going to turn it over to Pete to talk about unprotected speech principles.
Thanks, Mary. So remember, even from a couple slides ago, what type of speech is unprotected? It's pretty limited. It's speech that incites violence, speech that involves true threats, speech that are fighting words, or basically obscenity. And these cases that are listed here, most of which are either decades old, all of them, demonstrate that these principles have been around for quite a long time. And they also demonstrate that the standards that you consider with respect to what is unprotected speech is relatively limited even in those categories. So for instance, in this Brandenburg versus Ohio case, which has to do with what is violence or illegal activity, it says advocacy for such activity is constitutional, except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. It's not just something that creates a risk of it, but it's likely and it's imminent. So it's another example of even that protection, or an example of unprotected speech, is relatively limited. Similarly, in the Miller versus California case about what type of speech is obscene and therefore unprotected, the court described that where the work appeals to the prurient interest, depicts sexual conduct in a patently offensive way, and lacks serious literary, artistic, political, or scientific value. Again, it's an example where there are qualifications or qualifiers about what constitutes unprotected protected speech. It has to be patently offensive, and there's a subjective assessment of whether it lacks these other qualities. So it's hard for speech to not be protected. And the third case from the Virginia versus Black case in 2003 also addresses the true threat and what is an unprotected true threat. It has to be a statement where a speaker means to communicate a serious expression of an intent to commit an act of unlawful violence. So it's not just violence, and it's not just an expression of intent, but a serious expression and unlawful violence. So these examples indicate that there are nuances even for finding the types of speech that may be unprotected to be unprotected. Again, most speech is going to be protected, which is sometimes not intuitive to folks when you're trying to figure out what to do. Another key matter to keep in mind is how do you assess speech and whether it's protected or not? And the most significant concept here is that the context and the content matter. It's not just what someone said, but it's to whom they said it, how they said it, and the context in as much detail as possible. And you'll hear us say that a bunch today, that the details about how to address a particular speech issue and whether it's protected or not and what you can or can't do about it, the details of all the circumstances really matter. It's common for people to focus on just the content of speech, particularly if it's something that offends people and is creating concern that people raise on campus. It's sometimes the substance that creates the risk to the institution's reputation, but it's important to consider both the content and the context. The questions that are listed here are intended to illustrate the issues to keep in mind that you have to think through. They're not intended to clarify exactly when speech may or may not be protected, but it's kind of a rubric of things to keep in mind. Who's speaking? What role are they in? Are you at a university that's public or private? Where was the speech made? Was it about political issues? Was it a religious, where those two would be more likely protected? And was the target of the speech a public figure, which also can incorporate different types of issues to address and assess? So it's important to take the time to consider all these factors when you're trying to figure out how to respond to a free speech issue on campus, which can be challenging given the media cycle and the other reputational issues that you're going to be dealing with. So we'll talk a little bit about some issues relating to employee speech, particularly at a public institution, where there's a little more latitude for addressing conduct, even if it's speech. So there's a three-pronged inquiry that you consider. There are nuances to each of these, but it has to do with when a public institution can regulate or even discipline faculty or employees for their speech. The first factor is whether someone is speaking pursuant to their official job duties. If they are, that speech may not be protected no matter what it's about. And that's a significant question to be answering or considering whenever you're addressing a free speech issue on campus. It's a practical inquiry, though, about what someone's official job duties are. Courts have explained that it's not just what's listed on their job description. It's not just what they are absolutely required to do. So it's a more expanded version of what their duties are. It's about what their job would expect them to perform, and whether what they're doing is intimately connected to the work that they do, to their job. So it can be more expansive, particularly if you have people whose job it is to speak. If the role, for instance, as a coach, from the example Mary was talking about before, the recent Supreme Court case, where that coach has a role of speaking both to student athletes, but also generally to the public as part of their job, it may be more likely that their speech is pursuant to their duties and therefore not protected. There's a reference here to it's particularly challenging for faculty member speech, and at the end, the question of whether academic freedom is an exception. The reason that's listed as a question is because that's kind of an unanswered question in this area. It's referenced in a Supreme Court decision from almost a couple decades ago now in a footnote, and courts have not specifically clarified this yet, although it does create a question whether faculty speech that is subject to academic freedom, and we'll talk about that more later, whether that is still protected or not. It's more likely that it would be than other types of speech. The second two prongs here are a little easier to understand. The second is if the person is speaking on a matter of public concern. So if they are, it's more like then their speech is likely going to be protected or could be protected. And the issue of what is a public concern is generally construed pretty broadly. It can be anything that relates more generally to the community as opposed to just the person's specific job situation. The third prong here is more fact-based interest, which is even if it's someone speaking not pursuant to their official job duties and they're talking about a matter of public concern, you may still be able to address their speech if the institution's interest in promoting an efficient employment scenario or workplace, you compare that to the educational, if that outweighs the employee's right to free speech. This can be a very fact-specific question. And so from a litigation perspective, it's harder to prevail early in a case about that issue, but it is something to consider when considering how to address employee speech. And with that, I'll turn it over to Mary to talk about student speech.
Great. So now when it comes to student speech, that's going to be assessed a little differently than employee speech on campus. So the general legal standard is that student speech can be regulated pursuant to content neutral time, place, and manner restrictions. We're going to talk about that a little bit more in a moment. Student speech may also be subject to a substantial disruption standard, meaning that you can, regulate student speech that is going to, or that has substantially disrupted the operation of the school. What we aren't talking about in depth today, however, is student newspapers. We wanted to touch on them briefly because student speech principles implicate the freedom of the press through student newspapers. So before turning to these content neutral time, place, and manner regulations and the substantial disruption standard, I want to briefly go over the newspaper idea. So there's a prominent Supreme Court decision in the K-12 context, Hazelwood, which held that a high school could regulate the content of a student newspaper for reasons which were reasonably related to legitimate educational concerns. Now, there is some authority stating that the same principle can apply to school-subsidized student newspapers at colleges, but only in a very limited context. It matters how much control the college exercises over the newspaper. So there's a difference, for example, between a student article that's published in an alumni magazine managed directly by the university, compared to student articles published in student newspapers that are managed by students. So as a general matter, the school is not going to be able to, a college is not going to be able to exercise a whole lot of control or regulation over the content of student newspapers. That said, there are still institutional liability concerns that arise when it comes to student newspapers. So policies and practices regarding supervision of the newspaper, let's say, can give rise to claims based on a failure to supervise, either under a contract or negligence standard, and issues of defamation, meaning if a student newspaper publishes defamatory material, that could create both PR and legal concerns for the institution. Oh, sorry, this is moving around on us. So in a way, there's a strange dichotomy where a college does not, in most circumstances, have the authority to regulate the content of the student newspaper, but could, in certain cases, face some liability for what's published in that newspaper. But that's really complicated and deserves more time than we have time for today. We just wanted to make sure that we weren't forgetting the freedom of the press prong of the First Amendment. So jumping into the general student speech principles. Student speech cases often arise in the context of student organizations, but also come up in harassment cases, cases involving threats, and cases involving a student's right to protest. As a preliminary matter, Supreme Court jurisprudence makes very clear that First Amendment protections apply to college students. We have a quote: "State colleges and universities are not enclaves immune from the sweep of the First Amendment. There can be no doubt that denial of official recognition without justification to college organizations burdens or abridges the right to association under the First Amendment." And another quote: "In a series of decisions, this court has emphasized that the First Amendment generally precludes public universities from denying student organizations access to school-sponsored forums because of the group's viewpoints." So we'll talk about a few of those decisions. So as I said, student speech can be regulated by content neutral or viewpoint neutral time, place, and manner restrictions. This is part of what is known as forum analysis, which looks at whether the speech is occurring in a traditional public forum, such as a public park, or a limited public forum, which is where the government or public university has created a forum for speech and imposed limitations on that forum. In a traditional public forum, speech protections are the highest. Any attempts to regulate or restrict speech in a traditional public forum must meet what is known as strict scrutiny. The restriction must be narrowly tailored to serve a compelling government interest. In a limited public forum, however, there is a lower bar for the constitutionality of the restriction. The restriction must be reasonable and it must be viewpoint neutral. Viewpoint neutral or content neutral means that the regulation applies to all speech, regardless of the content of the speech. It does not regulate speech based on subject matter, topic, or viewpoint. The regulation is not based on what is being said, but rather how or when or where it's being said. And that's the time, place, or manner aspect. So on a college campus, we're generally dealing with limited public forums. So even though certain areas of campus, like your sidewalks or your quad, are similar to the traditional public forums of public streets and parks, courts generally hold that these spaces on campus are what is known as a limited public forum. And in conducting forum analysis, in figuring out what kind of forum we have, the court looks at how the space at which the speech occurred is used, why the space was created, why it was open to speech at all, if speech had been historically regulated in that space, and so on. So for those reasons, a college quad, for example, is typically a limited public forum at which content neutral time, place, manner restrictions can be imposed. So how does this work in practice? The court first held decades ago that where a university creates a forum that's open to student groups, it assumes an obligation to justify any restriction to those groups under applicable constitutional norms. And we can hold that same standard to apply just to student speech generally, where an area is open to student speech, there's an obligation that any restrictions on that speech meet constitutional norms, which again, content neutral, time, place, manner restrictions. So in 1995, in the Rosenberger case, the court looked at whether a public university could deny payments from its student activities fund, which was generally used by student organizations for printing and publication costs. If it could deny payments from that fund to a student group solely because the publication that they were going to be printing was religious in nature. And the court held that the denial of funds to the group, which otherwise met all criteria necessary to get student activities funding, was impermissible viewpoint discrimination, that a school could not deny funds to speech just because it was religious in nature. And the court did not agree with the school's assertions that its actions were necessary to avoid violating the Establishment Clause. And this is similar to what we saw, as mentioned earlier, in that Kennedy case more recently with the Supreme Court, where the school board, had shared that it was worried about possible Establishment Clause issues, and that's why I was asking the coach not to pray in a specific point, and the court disagreed with that assertion. So that concern is not given a whole lot of weight we see over, the decades of legal jurisprudence here. And the court in this Rosenberger case said, quote, "For the university by regulation to cast disapproval on particular viewpoints of its students risks the suppression of free speech and creative inquiry in one of the vital centers for the nation's intellectual life, its college and university campuses." Then in 2010, the court gave us an example of when a regulation is permissible. The university had an all-comers policy, which stated that to be an officially recognized student group, able to access funding and use facilities, the student group had to open its membership to all students. It couldn't have eligibility criteria for its membership based on the student members agreeing with its religious viewpoint. So the Christian Legal Society student group sued. It wanted to have a more limited membership, and the Supreme Court held that the all-comers policy was a reasonable viewpoint neutral condition on access to the student organization forum. And here we see this is an example of where the restriction applies to all groups regardless of their viewpoint. The rule is that student groups have to be open to everybody. They can't have eligibility criteria that would restrict membership to certain students, and that is a reasonable viewpoint neutral time, place, manner restriction. So that's forum analysis generally. And how does this apply not to the regulation of student groups, but to the regulation of a specific student's speech? In the 1981 case, Widmer v. Vincent, the court reiterated the principle that a university has the right to exclude even First Amendment activities that violate reasonable campus rules or substantially interfere with the opportunity of other students to obtain an education. And the seminal case for that principle, that a school can restrict speech that could be substantially disruptive or discipline students for substantially disruptive speech, is the Tinker case, which arose, it's a K-12 case. And I'm sure most of you are familiar with it. It held that the students' use of black armbands as an anti-war protest was protected activity unless there was some evidence that those armbands were causing a substantial disruption to the school environment. But even though as far back as 1981, the Supreme Court was saying that colleges can, restrict speech that substantially interferes with the educational environment, how far Tinker extends to the college campuses is still not entirely clear. Different courts have taken different approaches. The Third Circuit explained sometime in the past decade that the exact manner in which Tinker applies to the university setting is difficult to explain and evades any broad rules. In part, this is because controversial and sometimes offensive ideas and viewpoints are central to the educational mission of universities. And indeed, we've sort of seen this point that it's just not entirely clear how far that tinker substantial disruption standard goes in colleges. As recently as the Supreme Court's 2021 decision involving the regulation of off-campus high school speech. In that case, the court noted that off-campus speech can be regulated in certain instances, but the concurrence explicitly wrote that the case did not involve speech at a public university and that the decision did not apply to students at public universities. So to at least some extent, then, a college can restrict disruptive speech, but to what extent is really going to depend on the specific facts and the context. Finally, we want to note that even though the First Amendment does not apply at private schools, meaning private schools are not government actors and therefore can regulate student or employee speech without running afoul of the First Amendment, there's going to be contractual obligations that come into play. Your student handbooks, your employee agreements, and so on often have language that's relating to the speech rights of campus community members, including but not limited to with respect to academic freedom. So while a private school has some greater leeway to regulating speech, including speech based on viewpoint, it's still going to have to ensure that it's complying with its own policies. And sometimes those policies are pretty explicitly that they protect speech as, as far as the First Amendment does. So you're really going to have to be familiar with your policies and your employment agreements on campus to ensure that you're complying with those when regulating student and employee speech. Back to you, Pete.
Thanks, Mary. And this previous slide addressing private institutions and what Mary was talking about your policies, this sort of relates to the academic freedom issue, because our campuses create an environment on purpose where we want to encourage the free exchange of ideas. So the First Amendment principles are all very relevant, especially to public institutions, but they've also been largely incorporated into a lot of policies on campus, including on private schools, because we want to encourage open communication and speech. And academic freedom is another example of that, which is largely a matter of institutional policy as far as defining it. People largely, I think that they understand what academic freedom means from their own perspective, are often faculty or students when they're thinking about discussion about anything related to a classroom or area of research. But it's actually not all that clearly defined and will largely be require reviewing your own policies to understand it. We're going to just talk a little bit about it because it's kind of an extra protection outside the First Amendment that courts have said some about, but not as much as you might think, given how much people rely on academic freedom protections when something comes up and someone's trying to address their speech. It's not uncommon that someone says, I have academic freedom to say this, and they may or they may not, mostly depending on your policies. So what is academic freedom generally? We start here with a Wikipedia definition, just as an example to sort of orient us. It's the belief that freedom of inquiry by faculty members is essential to the mission of the academy, as well as the principles of academia, and that scholars should have freedom to teach or communicate ideas or facts, including those that are inconvenient to external political groups or to authorities, without being targeted for repression, job loss, or imprisonment. The concept is have an idea, have something, and information that you've engaged in from an academic or an intellectual pursuit, be able to explain it or address it to other people, even if it might be something they don't want to hear or is contrary to existing political norms. Because it's the expansion of thought and of intellectual inquiry. That's the basic concept. Another way of thinking about this came from Justice Richard Posner, who's been a judge on the Seventh Circuit and is very well respected, describing academic freedom. And this is just something to keep in mind. He explains that the term is equivocal. It is used to denote both the freedom of the academy to pursue its ends without interference from the government, so kind of an institutional protection, and the freedom of the individual teacher, or in some versions, indeed in most cases, the student, to pursue his or her ends without interference from the academy. And he notes that these two freedoms are in conflict. So that's true. Often the institution has a sense of its own beliefs about academic freedom and doesn't want to be subject to government influence with respect to that. but even more commonly have individuals on campus, say faculty members, who are extremely interested in their own academic freedom and protection from the administration, which may be trying to pursue its own mission or just manage employees or students and the community. And so these again, this is an issue spotting day that we're talking about. Academic freedom is very challenging to define, and it creates all sorts of concerns, but it's also essential to our institutional mission. So we want to support people pursuing academic ideas and explaining them and addressing them to people. So that's why this can often be a challenge to try to regulate or address. So this slide seeks to kind of just think about what the protections are and what the responsibilities are relating to academic freedom. And these quotes come from policies at different institutions. So first, it's a protection beyond the First Amendment. And the examples that could be included are things like a focus on academic inquiry and discourse, teaching, research, and publication, either inside or outside the classroom. It's easier to see it as academic freedom, the speech, when it's inside the classroom, but it may happen elsewhere. Sometimes it can also include public service. It doesn't necessarily have to, but it can. And it can apply to both faculty and students. But most academic freedom policies I've seen or worked with also include some kind of list of responsibilities and limitations on what academic freedom involves. And those limitations or responsibilities for people may include that we encourage counter speech. In other words, people speaking against what someone has said, and that's something that people should be ready to tolerate as a matter of academic freedom. And there also is some description of that we want to strive to be accurate, exercise appropriate restraint and judgment, foster and defend intellectual honesty, and refrain from claiming to be an official spokesperson. In other words, not everything someone says, even under academic freedom policy, would be subject to academic freedom protections or something that we couldn't address. And there's these are all subjective qualities here, right? Appropriate restraint and judgment. That can be challenging to work through and what that is, and it's sort of in the eye of the beholder, but these are concepts that often apply to academic freedom issues. And we don't bring this up to say, here's a clear answer. It's more that this is not an uncommon issue that comes up with respect to free speech issues on campus, and you want to look to your policies to help you decide how to address them. So with that, we're going to turn to sort of an overlay between free speech issues and First Amendment protections and academic freedom and the non-discrimination laws. And largely, you've probably noticed the slides we've been going through reference case law and standards that have been around for decades. And the overlay with non-discrimination laws and free speech issues is something that's more front of mind right now in the last year or two, particularly from the Office of Civil Rights, raising concerns about Title VI issues and student speech and hostile environment issues that have been happening or reportedly happening on campus and how schools should address them. So that's why we're going to talk about that for a little bit, because it's particularly topical. Just as a refresher, like what are the anti-discrimination obligations? Or there are many laws relating to discrimination that call for the regulation of speech if that speech is sufficiently severe, persistent, or pervasive that it is harassing. These come in, we've listed them here. You know, Title IX addresses sex discrimination, Section 504 and the Americans with Disabilities Act address disability discrimination. Title VI addresses issues of race, color, national origin, or ancestry. Title VII in the employee context similarly addresses similar concepts. All of these involve both discriminatory acts or the need to address any claim of harassment, so statements or speech that is sufficiently severe, persistent, or pervasive based on these protected qualities that we want to and need to do something about them. So that can include speech that might be protected under the First Amendment, and that's where the overlay comes. The history here of information from the OCR or positions from the OCR is worth taking a look at. From a 2003 Dear Colleague letter, which was rescinded several years ago now, there was this kind of language from the Department of Education and OCR indicating that OCR's regulations are not intended, so these are regulations relating to anti-discrimination laws. They were not intended to restrict the exercise of any expressive activities protected under the U.S. Constitution. Offensiveness of a particular expression standing alone is not legally sufficient basis to establish a hostile environment. And it went on to say harassment is not the mere expression of views, words, symbols, or thoughts that some person finds offensive, but rather is conduct that is sufficiently serious to deny or limit a student's ability to participate in or benefit from an educational program. So that standard really reflected a balancing of free speech rights and the restrictions that might place on addressing speech that someone thinks is harassing based on some kind of protected category from a discrimination perspective. Fast forwarding now to the last couple of years, we've seen sort of a different approach or a different emphasis really from the OCR about what particularly respects to concerns people raise about shared ancestry or ethnic characteristics. So for instance, in January 2023, they issued a fact sheet that explained that Title VI's protections extend to students experiencing discrimination, including harassment, based on actual or perceived that was related to shared ancestry or ethnic characteristics or citizenship, residency in a country with dominant religion, distinct or religious identity. This was I think, intended to address issues that related to concerns about conflict in the Middle East and issues that people were raising on campus. Similarly, in May 2023, there was a Dear Colleague letter that described that if a hostile environment based on shared ancestry exists and the school knew or should have known, that the school must have taken immediate and effective steps that are reasonably calculated to end that harassment and eliminate any hostile environment and its effects. These publications were not addressing questions about whether such speech might be subject to free speech protections, but they're focusing on the discrimination or harassment question. Then more recently, we'll list some slides here that address OCR standards generally. These come from resolution agreements that the OCR has entered into with multiple institutions across the country during this year in 2024 that address certain standards they expect schools to adhere to. And it's creating a very different focus on many campuses as to how to address concerns about harassing speech that relate to shared ancestry or ethnic characteristics. So for instance, these standards direct schools to assess whether cumulative incidents of offensive speech on campus could create a hostile environment based on those questions. Meaning one person reports some speech, but there's also at the same time public speech on campus addressing the same issue, perhaps at a protest, that other students heard that may have been spoken by different people. And the OCR is interested in us trying to address whether the cumulative incidents that occur relating to the person who reported that to us might create a broader hostile environment. It's a different standard to consider. Some of the complications in these kinds of cases relate to a complainant who comes forward. They may not want anything other than supportive measures. They may not want an investigation. They may not want to try to address a concern about a particular accused harasser. They just want to talk with somebody or maybe and have some supportive measures like counseling or other things on campus. And often those complainants may have only observed one incident or one comment, but other incidents may have been observed by other people who have not reported them. So these standards create challenges for us and how we can address them. These are more specific issues or concepts that come from the resolution agreements, and we're trying to summarize relatively lengthy agreements here, but these are a particular note, I think. These two concepts of imputed knowledge and constructive knowledge, and what the OCR is asking for our institutions to do, and when we might be found to be responsible for a harassing hostile environment existing. Imputed knowledge is the concept. It's described that if we had done a reasonable inquiry, but we didn't do it, and if that inquiry would have unearthed the existence of harassment, then the school will be treated as if we had knowledge of the harassment. In other words, we need to look more carefully if we want to avoid this imputed knowledge concept than just what one complainant tells us about an incident, particularly if it's a public protest of some kind. There's also this concept of constructive knowledge. So if the person who had engaged in the conduct and that's determined to be harassing, if that person is an agent or employee of our institution, say a faculty member attending a protest, whether they're doing their job technically or not, but if their role is an employee of our institution, it will be assumed that they were acting in their agency capacity. This is the OCR's indication of their standard. And they also talk about there's no requirement that a report have been made about such conduct. Again, they're trying to create an idea that we look into things carefully and more thoroughly when someone reports a concern or when we might hear about something. So this is our attempt. I like, Mary and I both like Venn diagrams. And this is our attempt to kind of sort of depict in an illustrative way the pickle that our institutions are put in here. We're the red box or the red circle in the middle. And where we're going to be held responsible, or we need to make sure we're trying to be as aware as possible of any and all available information about events that are happening on our campus that might relate to a complaint or information that we receive from different people. So at top there, you see a complaint that might come to our offices about a concern of harassment. That used to be where we start and end the scope of what we need to look at. Someone tells us about a concern and tells us what they learned. We look into whether there are witnesses who saw it or observed it. But under the standards that are being articulated by OCR these days on these issues, we also need to look at things like a comment or report by a student, parent, or other individual that might have been shared publicly or with someone else within our offices or an employee, information shared by community members, or things that employees have observed. So the OCR is indicating, and particularly in these resolution agreements, an interest in schools revisiting reports. In one instance, 60 different reports received by an office in a year. They need to go back and look and see whether there are other issues faced by other students or employees around the same time that could have led to this cumulative harassment concept and report on that. And OCR is also asking those institutions to apply that to concerns that they learn about going forward. So historical redo and looking at issues moving forward. So some of the complicating factors that relate to First Amendment protections in this area, and then we'll move on to some practical scenarios, is that some of the speech that can be directed at shared ancestry or ethnic characteristics may be political speech that has some strong First Amendment protections. Remember, even hate speech is protected by the First Amendment. People often forget that. But generally, speech is protected in the absence of any true threat. Remember, we talked earlier, unprotected speech is relatively limited. So there's some tension between considering the speech, this cumulative hostile environment idea as harassment, as that's independent from speech protections, when it may not be based on what we do in terms of investigating. And there are also concerns about free speech protections can sometimes include the goal of not chilling speech, and that subjecting someone to an investigation itself could be considered chilling if their speech was protected. So these are challenges to try to navigate that we just want to articulate as sort of very present today, and something a lot of schools are working hard at trying to address. So with that, we're going to move on to some practical scenarios to try to sort of illustrate some of these issues.
So before we jump into these hypotheticals or practical scenarios, we just want to note that some of these involve hot button political and cultural and social issues. We're taking efforts to discuss those issues in a manner that is sensitive, but also practical, because we know that you're dealing with these on campus right now. We don't have answers for you, I'm sorry to say, but hopefully walking through the scenarios will highlight the legal frameworks that we've just discussed and give you some guidance when you're approached with these similar issues on campus. So our first hypo, this is a professor who addresses students using the title Mr. and Ms. accompanied by their last name. So Mr. Land. The school has a policy regarding students' preferred pronouns that says those should be respected. There is a transgender student in this professor's class who asks to be called Miss with her last name. The professor objects, stating that compliance violates his personal and religious beliefs. He believes that gender is assigned by God, and that because of this, gender and your biological birth assigned sex are equivalent. So this hypothetical is a real case actually out of the Sixth Circuit a couple of years back. I'm sure most of you are familiar with it by now, but the professor requested that he be permitted to put a disclaimer in his syllabus that he was following the school's pronoun policy under duress and explaining his own personal views on gender identity. The school told him he could not do that. He then decided that he was going to refer to the student only by her last name. So he was going to not use the Miss, but continue to use the Miss and Mr. for all other students. The student filed a Title IX complaint alleging that this was harassing or discriminatory towards her based on her gender identity. And the professor was found in an internal investigation by the school to have created a hostile environment under Title IX for this student. The professor then sued, bringing free speech and free exercise claims. So first at the district court level, the court found in favor of the university. It held that the professor was speaking pursuant to his official duties in class, and therefore he was not engaging in protected speech at all. The Sixth Circuit, however, reversed. It first found that the employee speech doctrine, which Pete had discussed earlier, did not apply to the faculty's in-class speech because, quote, a professor's rights to academic freedom and freedom of expression are paramount in the academic setting, and, quote, professors at public universities retain First Amendment protections, at least when engaged in core academic functions such as teaching and scholarship. So this is what Pete was talking about earlier about how it's a little unclear to what extent academic freedom principles kind of create a carve out of to First Amendment carve out to the employee speech doctrine and employee speech principles under the First Amendment. In this case, the Sixth Circuit held that the professor's use of titles and pronouns in class falls under academic freedom because, quote, choices about how to lead classroom discussion shape the content of instruction. And so the court ultimately held the professor was speaking as not pursuant to his official duties because that analysis did not apply, it held in the classroom. It held that the relevant analysis was whether he was speaking on a matter of public concern and whether his interests in protected speech outweigh the school's interests. So those are the last two prongs of the three-prong inquiry that Pete went over. So the court held that the professor was speaking on a matter of public concern, held that issues of gender identity are matters of public concern, and it found that the professor's interest in his protected speech outweighs the college's interest in stopping discrimination against transgender students, particularly because it was, in the court's view, a win-win to have the professor use the student's last name alone, because then he did not have to violate his religious beliefs and the student wasn't being referred to using pronouns that she found offensive. To be honest, I'm not entirely certain if this case would shake out the same way today, only a few years later. And I do think it's going to be really court dependent and it could vary by circuit. That said, it does demonstrate the strength of protection for speech, particularly speech which is religious in nature.
So here's another hypothetical to consider. This comes from some of our own experience, actually. But so if you have a business management faculty member who has an exam question in a course about dispute resolution, and in that exam question, it describes a workplace example with detailed reference to sexual assault. So the course is not about sexual assault issues, but the example in a test is. Students in class complained that the question was too graphic and created needless stress during an exam and was even traumatizing to some. Social media posts ensue and lead other students to complain about the same professor's 2-year history of insensitive classroom comments on gender and race issues. Apology emails from the faculty member include jokes and note the faculty member's prior efforts to help one complaining female student that won't be repeated in the future. The press picks up on this story and the board suggests quick employment action because of the reputational interests at stake here. So some of the questions that stem from this example is the professor's speech protected? So a first question might be, is this pursuant to the job duties of the professor to speak in class under the First Amendment? Probably is pursuant to the professor's job duties because it's in class and it's on exams. But is there an academic freedom protection that exists here for the way that the professor decides to teach the class? Sometimes you hear professors say that depending on the course, teaching, if this was in a law school or a business environment where they think people need to learn how to operate under pressure, they might say that the fact that they feel some tension based on the nature of the question and exam is part of what they're trying to teach them to manage. And is that part of academic freedom? So it might apply. The real question sometimes in these areas is who should decide that? Is it the office that handles discrimination complaints that often would not be all that well-versed on academic freedom issues, or should it be some kind of faculty body or faculty administrator who somehow weighs in on this? Those are challenges that can come up that can be difficult. We don't have clear answers on that. There are issues that have to be addressed. Then there's a question of, is there harassment in this case? And should consideration of all the complaints, so both the exam and the complaints that came up in social media posts, should they be considered about comments that were allegedly made over a 2-year period of time in different classes? It's critical to look at the harassment policy language to understand that. And then you need as much detail as you can get about those examples. Like, were there students who knew in this current class who took the exam about the prior examples of other allegedly harassing statements in prior classes? Because that accumulation like that can matter in these kinds of cases. So you really need to know as much as you could about the circumstances. And how quickly can this be resolved? This is an example where this could be challenging. You might want to address it as quickly as you can because you have an ongoing class in a semester and you want that class to proceed well. And you also, the school probably doesn't like the reputational issues that the media reports about this are creating, but it can be very challenging. The faculty member has rights and there are processes that apply to harassment investigations and the like. So it's important to be very careful and think through this very carefully. So this is not designed to show an answer, but sort of the thorniness of some of these questions. So I turn it to Mary for another hypothetical.
So here we have a facilities management employee at a public institution who makes a report that a coworker in the facilities management office has made a series of derogatory statements about the war in the Middle East and about the extra work the potential for protests on campus has created for the facilities management office. This staff member's comments also allegedly include, quote, those people should respect the university's property, and, quote, they might get themselves hurt if they don't. The accused staff member also reportedly has had some anger management issues and over the past few years has yelled and sworn at students. The complaining staff member is of Middle Eastern ancestry and alleges this history of interactions has created a hostile work environment. So what are the risks here? Well, first, there's the institution's obligation to comply with non-discrimination laws. We have Title VII, which applies to employees, and we also have Title VI, which applies to students. The university has an obligation to investigate whether the complaining staff member is being discriminated against or harassed on the basis of his national origin or his ancestry. The university also has an obligation to figure out if any students have been subject to a hostile environment by this staff member. And this is what Pete was talking about earlier. Remember, OCR is taking a really broad approach to Title VI issues. So the university, upon report from the complaining staff member that there is an employee who allegedly has engaged in derogatory statements, potentially about a coworker's ancestry, and is also known to have yelled and sworn at students, the university has an obligation in that situation to figure out whether the conduct towards students is based on race or national origin or ancestry, or if the guy is just what we like to call, an equal opportunity jerk, if he's just yelling at all students. The university also, the university has its interest in workplace efficiency and workplace culture, which is being impacted by this situation. And then there's the staff member's right to free speech. The complaining staff member has raised the concern that these comments are ancestry-based, but without investigation, there's a potential for improperly characterizing the speech. We have to figure out, is it speech about ancestry or is it speech about political beliefs? And then over all of this is the institution's own mission, which likely, advocates for the free expression of ideas, advocates for civility and discourse, puts educational goals and educational engagement first and foremost, has goals of inclusivity on campus. So all of that is sort of percolating in the background of trying to address what's going on between these two staff members. So what should the institution do? It needs to complete an investigation under the non-discrimination policy, it'll at least be the Title VII policy, but possibly the Title VI policy as well. The investigator needs to get specific details about what was said to whom and when. If it's not clear, what's the basis for, believing these comments to be about somebody's ancestry, or versus, again, just, comments about the, workplace efficiency, that sort of thing. Were the comments about, these people specific to an ethnic group or ancestral group, or was it, shorthand for all students engaging in any sort of work on any sort of activity on campus that made this guy grumpy? To figure out how broad the investigation needs to be and what responsive action the university needs to take, the investigator should probably ask questions like, do you know of anyone else who has experienced similar issues? Is there any other conduct, even by someone else, that contributes to your feeling of a hostile environment? And just how far you have to go is not entirely clear, but we do know that it is a little further than perhaps was necessary 10 or 15 years ago. And then, it'll also be important to delineate or differentiate between conduct that implicates Title VI, Title VII, and then the conduct which is generally non-discriminatory, but might be unprofessional in some other way. And then, of course, the freedom of speech principles overriding all of this. So it'll be important to differentiate between comments that are about ancestry versus comments that are about political issues, which could be ancestry adjacent, but likely given speech protections because they are ultimately about political issues. And finally, especially where there isn't a finding of discrimination, it might be appropriate to address the complainant's concerns in another matter. For example, there is a simple resolution such as supportive resources to the complainant and agreed shift or location change for the employee. And we know that one thing OCR is looking at closely is how the investigation is documented and what resources were provided. So we are coming up, we're about a minute and a half over. So just really quickly, the key takeaways that we want you to have today is that, every speech situation is unique. It's really fact specific. The details matter. What was said by whom, to whom, and in what context is all really relevant. And the decision makers must be prepared for a challenge here. They have to balance the need to carefully assess those details against the desire to make a public statement or take some other immediate action. A simple no comment these days is itself going to draw criticism. And ultimately, we know this is not necessarily satisfying guidance, but schools are going to have to be ready to make difficult decisions and face a lot of criticism as they strive to comply with First Amendment requirements and academic freedom principles, while also complying with non-discrimination laws, while also adhering to their institutional mission, vision, and values.
Thanks, Marian. I know we're right at time, so we will be responding to questions by email. We appreciate them. You can submit more questions to us by email if you have them. We very much appreciate you joining us today. We hope this information was helpful. And again, remember that a PDF of the presentation is available in the program materials folder. So thank you very much and have a fantastic day.